All right. Can you hear me in the courtroom?
I can, yes.
Perfect. All right, let me see where we're at here. We had a little bump in the road there. Things didn't work like they were supposed to, but now they seem
I
to be
can,
working.
yes.
And we are streaming. Okay. Just a minute here. I'm trying to get myself organized. Okay, let's go ahead and go on the record.
We're on the record, Your Honor.
All right, thank you. Good afternoon. The July 19th guardianship probate docket. Judge Basher presiding. Do we have any matters to go off the docket today? I'm not hearing any. I have gone through the docket and reviewed most of the cases, so I'm going to run through the ones where it appears everything is in order. Starting with 23-4-26308, the estate of Thomas Troop. Mr. Peterson. See Mr. Peterson, I'll come back to that. On the guardianship of Gabriel Medina, 034154-3. I did review that one, and that appears to be in order. I've approved those orders.
Thank you, Your Honor.
Welcome. And then on the guardianship of Nicholas Wilson, 07446-0. Is there anybody objecting to this matter? Mr. Claxton.
Good afternoon, Your Honor. It's Laura Mantuso. For Mr. Wilson, I believe I sent in Mr. Claxton's signature report by mail on that order.
This was the order changing. Oh, it does have his signature. Very good. All right. I didn't expect there would be, but I hadn't looked at the second page of the order, so I will approve that.
Thank you very much.
All right, so that will go to the clerk. All right. Here. Then we have guardianship of Joseph Peterson, N4131-8. Ms. Pruhan, I have approved those orders.
Thank you, Your Honor.
Guardianship of Mark Gadula, 12446-6. Reviewed that matter, and those orders have been approved.
Thank you, Your Honor.
Welcome. The guardianship of Emmeline Nelson, 16472-8. Again, I've reviewed those and approved those orders.
Thank you, Your Honor.
Guardianship of, just a second here. Linda Erlenbush, 22-4-52608. Anybody appearing objecting on that matter?
We've served all parties and we've not received any objections. We have the two orders to approve the sale of the property and then the orders, or I'm sorry, the plans and inventory.
Everything looked to be in order. I just wanted to make sure we didn't have an objection on the sale, so I have approved both of those orders as well.
Thank you, Your Honor.
Welcome. Guardianship of Lori Donath, 22-4-52708. I did have a chance to review those. Hold on a second here. I did review those. Those do appear to be in order as well, and I've approved them. And let me see here. Mr. Peterson, I see you are here on the the Thomas Troop matter, 23-4-26308. There was a consent filed. I did approve those orders as proposed.
Thank you, Your Honor. I appreciate it.
Welcome. Anybody here on the guardianship of Richard Allison, which is 20-4, 27808? Richard Allison. All right, we will need a show cause order on that one.
Okay, thank you.
Mhm. And then on Ms. Farr, I've got a couple of years, it looks like, on the guardianship of Leo Morgan, 23-4, 203-08. I did not have a report yet.
Yes, Your Honor, I'm still waiting for some chart notes from the doctor's office before I can complete that report.
Okay, how much time do you think you need on that?
I think Ms. Prejean and I talked about maybe setting it out a month.
So that would be August 16.
That sounds good. August 16th at 1:45.
Thank you.
Thank
You're
you.
welcome. Then I had another matter, which is the guardianship of John Michael Wiggins, 84-4, 9-9. It looks like this is like Ms. Farr was appointed, and I don't know if I didn't see a report on this one.
Yes, Your Honor. So I was only recently reported and recently appointed. And so I'm just beginning my investigation, and there's some things that need to be done. I need to get a medical report. I need to get a medical appointment set for John first, and then still complete some interviews and before I can go forward. So I need a little more time on this one as well. I did talk with Mr. Mattson about that.
What timeline are you looking at?
I'm thinking about a month as well.
Okay. Mr. Madsen, does that work for you?
Yes, that's my understanding. We spoke about it. Yes, no objection here.
Okay, so that would be, you want the 16th as well on that?
Yes, please.
All right.
That would be fine.
I'm familiar with this case, I think I heard a lot of the foreclosure matters, and so I am familiar with the status of the case. So we'll set it over the 16th. Hopefully we'll have a report and can move it forward.
Thank you, Your Honor.
Okay, very good. I believe that is everything on the guardianship docket. So we'll be starting up the civil docket in just a few minutes at 2 o'clock. So the streaming will be on, but we will be off the record for about 10 minutes. So if you're on the Zoom, if you want to go ahead and mute yourself, and then we'll restart, we'll unmute and head back into this in just a few minutes. All right, if we can go ahead and go back on the record.
We're on the record, Your Honor.
All right, good afternoon. This is civil docket for July 19th. I've got a couple of uncontested matters that appear, so I'm going to run through those real quick here. Is Anthony Del Vecchio present?
I am present, Your Honor.
All right, good afternoon, sir. This is case number 23-2601-08. I have approved your order restoring rights. That was not objected to by the prosecutor, so everything's in order.
Thank you. I appreciate that.
Yeah, you should be able to get probably copies of that. Will probably available, and then give it a day or two with the clerk's office and they'll be able to get you a copy of that.
Okay, I appreciate that. Thank you, Your Honor.
All right, you're welcome. Christopher Leach. I think I saw him on here. Christopher Leach. 23-2635-08. I have also approved those orders. How about David Bosson, 23-637-08. David Bosson. I have approved those orders. And then Corey Center, 23-652-08. We have a Corey Center present.
Yes, Your Honor.
All right, so I have approved those orders as well. And again, you'll be able to get a copy from the clerk's office, probably give them a day or two and they'll have that ready for you.
Well, thank you.
You're welcome. All right, I think everything else here, let me try and kind of stage these in the ones that the order they appear to be the quickest. So Hillman and Hillman, which is 23-218-08. Guess I'm Mr. Penta and Ms. Baldwin are present.
Yes, that matter's ready.
Yes, thank you, Your Honor.
So I don't know if there's some agreements on this or.
So we
It's
did,
my motion. It's my motion, Your Honor. Sorry, Chelsea. The parties are in substantial agreement as to the main issue here, which is the sale, and also they've agreed on the listing agent. Council have shared alternate versions of a final order that I don't believe need to be argued at this time. I have prepared or refined a simpler order that is before the court, and it still would obviously allow the parties to engage the court if they reach any substantial disagreement along the way. But the good news is that they both agreed to sell, they both agreed to the listing agent.
Ms. Baldwin?
you. Did the court receive Ms. Hillman's declaration along with my proposed order?
I received, yeah, I did.
Okay, very good. So I do have concerns with Ms. Penta, Mr. Penta's proposal. First off, it doesn't deal with who is going to pay the mortgage, maintain the property. currently. That should be managed prior to sale or while we await sale. Second, it sets the listing price too low. Mr. Penta certainly isn't an expert. He's not provided any expert materials sufficient to set the list price. My proposed order is essentially that the expert we've agreed on, Ms. Ewald, will assist the parties in setting the price, the list price. If the parties can't agree, it sets forth a procedure for how we can resolve that quickly and efficiently. And the same with the sale price. Both parties are in agreement to sell. Both parties want to achieve the maximum value. So I don't really anticipate significant issues here. My client is the one who filed the action asking to be able to sell the property. Next, my order deals with necessary repairs. Both orders do to some degree. Mine is more clear about sort of how those are reimbursed and the fact that they will be reimbursed. Mr. Penta's, I believe, is silent as to reimbursement, which is not appropriate. That could have one party being essentially ordered to make repairs and then not reimbursed the cost of those repairs. So again, not appropriate. There are judgments on the property. Those judgments are not only the underlying guild mortgage, but there are tens of thousands of dollars that Mr. Penta's client owes to my client in judgments from separate cases. The most significant of those are judgments that Your Honor ordered. As well, some of those are also due to the Cowlitz Superior Court. The concern is, again, Mr. Penta's order does not say that those judgments are to be paid. They should be paid upon the sale of the property. Next, Mr. Penta's order does not deal with what happens with monies in escrow. These are not sale escrow, but the standard escrow that the mortgage company holds for taxes and insurance. That should be clear that that becomes sort of part of the net. As it stands, I believe Mr. Penta's client would just would receive those monies, and this order would allow him to pocket them inappropriately, even though my client is the one that is currently paying the mortgage on the home. And then finally, Mr. Penta's order proposes that the clerk of the court maintain the sale proceeds, and I just don't find that logical. The clerk of the court should not have that obligation to store those funds. I don't care whose trust account they go in, but they should go in either Mr. Penta's account or mine. To my knowledge, neither attorney has ever mishandled funds from our trust accounts. There's no reason to place it with the clerk of the court. That's just odd. So I'm asking the court enter my order. It resolves and deals with all of the issues and instead of sort of cherry picking ones and leaving significant ones such as existing judgments on the property undetailed. Those are things that are important that we handle and ensure that they are paid.
Mr. Penta?
Yes, Your Honor. Well, the price actually is not set too low because the price is the median between the two brokers' prices of opinion that counsel are aware of. And my proposed order simply states that it's going to be that or higher. So we're certainly not setting a price that's too low. As for the judgments, we're treating this like any escrow. Ultimately, the judgments are going to be paid on closing. There's no question about that. There's no need to clutter up an order from the court that the judgments have to be paid to clear title. That's quite obvious and quite routine. As to the closing proceeds, to me, it seems like the most neutral holding agent for those proceeds would be the court registry. The parties are obviously not fond of each other. I'm treating this like a very straightforward sale. It's a straightforward partition. I think Chelsea's coming at this from her experience with domestic relations and all the emotion and battles that involves. I want no part of that. I'm steering Mr. Hillman away from any of that nonsense. We're going to focus on the practical aspects. And we're both obviously entitled to come back to the court if there are any disagreements. Dealing with repairs when there are no known repairs, the market research, but I would say that the market preparation report, if any, hasn't been received from the listing agent. So I'm not aware of any repairs. And so to hypothesize that there are going to be repairs and then worry about how they're going to be addressed, I think is a matter not necessarily before the court at this time.
Well, I guess my concern is this: there's apparently not an agreement on the price. So that
Well, we don't have to be, Your Honor. We don't have to be in agreement on the price. because the price is going to be set by the listing agent. And number 3 in my proposed order is simply stating that if the price is not 331 or more, then we'll bring it back to the court if the parties can agree. I expect that they'll both agree if it's higher to that. They have the same goal. Fortunately, they both have a need to have the property sold as soon as possible. And I expect that we will defer to Sherry Evolve in this matter in terms of any market preparation and final pricing.
That's why my order is better, because it doesn't have a specific number that's essentially setting a floor or a ceiling for the price. It allows our agreed expert to assist the parties in setting that, and then creates a method for the parties to quickly and efficiently resolve any dispute. And similarly with the sale, is if the parties dispute, there's multiple offers and those offers have different contingencies, how do we resolve that? If somebody says, oh, I want the contingent offer because that's worth, $25,000 more, the other person wants it not to be contingent, maybe there are differences that are both bona fide per Mr. Penta's proposed order, but how do you select between them? Mr. Penta's order doesn't have essentially anything built in, where mine does, and that's because offers are really time sensitive often, where you have to have a decision made within 48, 72 hours. And so mine has a mechanism built in for us to get a quick answer from the court. So that's why, again, in the list price, haven't set a floor or a ceiling, because that's really the expert's job.
All right. Well, fortunately or unfortunately, I am familiar with the other cases related to this case, which I think probably, the orders are essentially duplicative. There's more detail and there are some more guidance built in, which ultimately should minimize excess costs such as attorney's fees or court actions. So I'm inclined to go ahead and adopt the proposed order from Ms. Baldwin. Mr. Penta, if you're concerned about the money going into the trust account, which I think either one of your trust accounts probably makes more sense than the clerk, just because it's simpler to deal with. You don't have to come back, get a court order, get it out. I can put it in your trust account if you're more comfortable with that. It doesn't really matter.
I have no opinion. Yeah, it can go in his or mine, doesn't matter.
Mr. Penta?
I'm prepared to have the funds in my client trust account.
Okay, I'll make that one change on line 7. And that'll be the only change, and I'll adopt the order. I think it does give a little more guidance and covers a little more of the potential. I think just sets a little better guideline, so I'll adopt that order with that one change.
I think, Your Honor, that you'll be changing number 6 as well in that regard then. There's also a reference to
correct. Thank you. So 6 and 7 will both refer to Mr. Penta's trust account.
Very good.
And I have signed that order. All right. Have a good afternoon.
Thank you.
Thank you.
All right. I see Mr. Bob, Miss Winkles, I think I saw logged in. Is Mandy Gronitz or anyone representing her present? Mandy Gronitz or anyone representing her? I'm not seeing anybody. So I don't know that I saw an order on this.
No, Your Honor. I will have one sent to your office tomorrow morning.
Okay. I'll approve the order as requested.
All right. Thank you, Your Honor.
Welcome. And let's see here. I'm going to run through Tejada and Wynn, 22-28908. Ms. Long, Mr. Wallace, I see you're both here. Just a second, let me get down to that. Hold on a moment. Right piece of paper in front of me. Okay. So I've got 3 motions. One is motions in limine. I don't think I saw. Well, there is a response. I'm sorry. It wasn't until when I looked earlier. All right, I'm going to come back to this one. I did not have a chance to go through the response prior to court. I did not see that when I looked earlier for prepping for docket. So let me run through the other two cases real quick, and then I'll come back to that. My apologies, counsel. That was my oversight.
Okay, Your Honor. Thank you.
All right. Shepherd and Shepherd, which is 23-2-66108. Mr. Anagnostou and Mr. Lanza.
Yes, good afternoon, Your Honor.
Good afternoon. So did you get Mr. Anagnostou's client's response on this?
I did, Your Honor. The responsive declaration of Norma Shepherd, I did get that yesterday.
Okay. So I guess just from, as where we stand right now, I understand the water's back on. Is that right?
That's correct.
That is correct, Your Honor. The water was restored, according to my client, the morning after the temporary restraining order was served. So we did accomplish that. And I believe, as far as the scope of this motion, I believe the parties are in agreement in several respects. However, of course, this responsive declaration is a little confounding. I want to just clarify the scope of the injunctive relief we're asking for. The first facet of it is to get the water on. That's already done. We're happy that that's no point spending more time on that. What we're asking for on the second facet is an injunction preventing the defendant from interfering, terminating, or otherwise cutting off the water again. That's the full scope of the injunctive relief we're asking for. What appears to be at issue for today, this afternoon's hearing, is there appears to be a disagreement about who is going to have an ongoing responsibility to effectuate any needed repairs as they arise. Well, we do have this invoice that seems to suggest there may be some additional repairs that need to be done. My position is we'll take that up if and when it becomes an issue. But the immediate relief, the issue that required this kind of emergency temporary restraining order was just to make sure that the water continues to flow and to stop the defendant from stopping the water. Now, turning to the responsive declaration, I know the defendant alleges, well, I turned it on when I initially received a demand letter, it was on, but then unbeknownst to me, this pump failed. And when I got the second order, lo and behold, the pump gets fixed. I have certain reservations about the recounting of events and that timeline set forth. I would point to the exhibit attached to the declaration, this well drilling invoice where it says service call to troubleshoot no water, customer had turned power off to the pump. I'll just stop right there. I think that the evidence presented by the defendant kind of establishes that someone went in there and turned the power off, disabled the pump. That's exactly the type of behavior this injunction is trying to enjoin and prohibit. So as far as who's responsible for ongoing maintenance of the well, who pays for any repairs that may arise in the future, I just don't think it really stops us from entering an injunction to prohibit the defendant from going in there and cutting off the water. That's all we're asking for. We want to keep it simple and straightforward. And if that can be agreed upon, the only real substantive dispute here would be the necessity for a bond. We are, of course, asking that this injunction issue without a bond. We were able to get the TRO without a bond, but I did acknowledge that, typically in these situations, a bond is routinely required. However, the purpose of the bond is to protect the defendant from any damages they may suffer if the injunction is later sued out. Now, my position is that there is no damage to the defendant for merely having to abide by an injunction to not go into the well house and turn off the power and cut off the flow of water. I mean, what damage is imposed by the strict, prohibitions in the injunction that we're asking for? So we would ask that there would be no bond required. If the court is inclined to order a bond, we would be prepared to post a modest bond, perhaps to, cover $1,000 in attorney fees or something like that. If it turns out for some reason we weren't entitled to get this order, but we don't believe a bond is appropriate because given the limited scope of the injunction, we don't believe there's damages, any likely damages to be suffered by the defendant.
Doesn't the statute require a bond?
There is language that does, Your Honor. I would just say that, these are equitable. This is an equitable mechanism, equitable powers of the court. As I said, if the court is convinced that a bond must be posted, I would ask that a nominal bond be required in the amount of, say, $1,000, $2,000, something along those lines, if the court is inclined to do that.
All right, Mr. Anagnostou.
Yes, Your Honor. I mean, I guess we object to this an ex parte order, injunction is an extraordinary relief in these type of circumstances. As between any landlord and tenant, generally, tenants go out and get utilities to their units and, they pay the bill. And if they don't pay the bill, it gets shut off. I mean, landlords aren't involved in that. To ask for an injunction against a landlord is just extraordinarily request. That changes the status of the parties. So, the plaintiffs here are, tenants on the property. If services are disconnected, they have relief. I mean, the statute, the landlord tenant statute provides for, it used to be $100 a day. I'm not sure if that's gone up since I've looked at that statute, but if you terminate utilities, this is a little bit different because there's a well, and the well is on the tenant's property, and there's they don't get a utility bill, but my client went down there and she got the letter from council that indicated if the water's turned on, we won't have to do anything. And she went down there and made sure it was turned on. And then at some point it went out, and to a certain extent, this motion makes my client an insurer to provide water services to the tenant, which is a change in status. And so, on those principles, we object that we shouldn't be here. If the court's going to grant a preliminary injunction in these circumstances, then it should be with a bond, so that if there's any issues in the future that there's recovery that's necessary, that there's a bond in place. So my initial objection is that landlord tenant actions shouldn't warrant preliminary injunctions between the parties unless by contract there's something that's here. They have no contract, so we're looking just at the statute, and then if the court is going to grant it, that there's some kind of bond be put in place.
Your Honor, if I may reply to that, I understand counsel saying, well, by issuing this injunction, it's making us an insurer. I disagree with that characterization. I think this injunction is really to as I said, enjoin willful termination of utility services. That's all this is asking for. It's to prevent her from committing essentially a tort, or, I guess a violation of the landlord-tenant relationship by intentionally interfering with utility service. We're not asking that she become an insurer. We, of course, will fight out the merits of the case. But for now, we're just trying to stop her from coming in and cutting off the water. Now, the other point being, well, the Landlord-Tenant Act does provide for a remedy, this $100 a day penalty. That's true, and that likely will come up in the course of litigation. But I find it slightly disingenuous to say, well, you don't need an injunction to stop us from cutting off your water, because if we cut off your water, you come after us for $100 a day. And in the meantime, you have to sit in that mobile home with no water because during this, elevated heat wave that we have dealing with here locally. It doesn't make sense, Your Honor. So we'd just be asking for a very simple injunctive order: turn the water on and don't do anything to turn off the water. That's it.
So does anybody have a copy of this lease?
There is no lease, Your Honor. There's a oral lease agreement, but I think the parties have acknowledged that.
Well, here's my question. Who's responsible under the lease agreement? The well's on your client's property that they're leasing. So they have access to the well to turn it off, on, do whatever they want to.
Correct.
I don't know who's responsible. I mean, they both use the well?
No, they do not, Your Honor. I believe that the defendant's property is served by another well. I would point, if we're in 5918, there is landlord duties, 5918-060 is.
That's not the question. The question is who's responsible under the lease agreement to maintain that well on the property your client is leasing?
Well, I believe the statute puts on the landlord the obligation to maintain all electrical, plumbing, heating, and other facilities on the leased premises. That's what I would hang my hat on, Your Honor.
I think you need more than that. I mean, if she's the tenant, she has to ask your client permission to go onto the property to turn the well off or on.
That's the well is actually located on a 5-acre parcel that my client leases.
Right.
The 5-acre parcel is owned by the defendant.
I understand that, but she can't go on that property if your client is leasing it. It's your client's property unless she has permission to go onto it.
The landlord,
something otherwise.
In the situation where a tenant is being deprived of water, and in those types of circumstances, the landlord is absolutely entitled to go in there and make emergency repairs. I think lack of water during an excessive heat wave would be emergency repairs that would entitle her, nay, require her to go onto the property and restore the water, which is what she eventually did. We had to go through a lot of steps to get there. It required court action, but the water is restored. And what we're saying is, please do not come onto the property and turn off the water like she did in the past, which we believe is supported, not just a baseless allegation, supported by her own declaration saying customer had turned power off to the pump. And although not supported in the evidence just yet, but there was a lock put on the well house by the defendant. Now, we'll get declarations to that effect, but really we're getting into sort of the nitty-gritty details that we will certainly be litigating, damages and the like. But right now we're just saying, please don't shut off our water. That's the scope of our request.
The well is located on the plaintiff's property, and there's no lock to it at this point. The issue is the electricity that runs the pump comes through my client's meter. But we understand that she can't terminate any type of utilities, but the pump is the responsibility of the tenant. They have to get their own water service, as tenants do in most residential places, but it's by going through a city or some kind of water district. Here, it's just a pump that's on her property that she needs to maintain. My client will keep the electricity on through this litigation.
All right, so I guess here's my concern. The only declaration that I have in the file besides Ms. Shepherd's is Mr. Lanz's declaration. I don't have any other declaration.
We did have a verification on our complaint, Your Honor. That's the verified complaint signed by my client.
It's not a declaration in support of the motion. That's just she's saying that this is the cause of action. Let me just see what that says. So, I mean, as a practical matter, I don't know who's responsible for maintaining the well. I don't know who's responsible for repairing the well. If she is supplying the electricity, and I don't know what the agreement under any, I mean, you've got an oral lease, so I don't know how you're going to show that, but at this point, Megan, I'd be happy to sign an order that says she'll not shut off the electricity of the well. It's on now, as I understand it.
Correct.
Yes.
Second here. And I'm looking at your complaint. It says it's a 99-year lease that he gets to put, the original person was able to put the mobile home there. And then it says the 99-year lease required him to maintain the property in exchange for use of the property.
That is correct, Your Honor. That's why I'm saying I don't think maintenance is really at issue here. What we're trying to prevent is willful termination. I'm charged with maintaining my well, but you can't come onto my property and sabotage my well, I guess is all we're really asking for. So I think we want to keep the scope of the injunctive relief narrow. And as far as who's maintaining it, I don't think we have an issue about it. I'm required to maintain a fence, but if my neighbor comes over and smashes it with a sledgehammer, I mean, we can enjoin that without really addressing my duty to maintain anything.
Manager. Well, I'll sign an order. I don't know if I've got an order that I can work with here. Let me see. So probably gonna need a different order, but under the order section, I'll grant an injunction. I'm going to delete out 2 about restore that's been done. Leave in number 3, that's essentially the intentional termination. It'll require a $1,000 bond.
Your Honor, as for the timing of posting of a bond, I do have an insurance carrier that I work with locally to get those types of bonds. However, could we have 14 days to get that. We do have to submit an application.
That's fine. Okay. The bond will go into effect under the condition that that's, and it would essentially would dissolve if it's not done within 14 days.
Understood.
But that language probably needs to be in an order. So council, I'm gonna let you work on some language in an order and submit that. That can be done ex parte. I can put this on for Friday at 8:45 for this Friday or next Friday if we can't come to an agreement on language on the order.
I believe we can come to an agreement on language, Your Honor. I don't think that'll be necessary.
Mr. Anagnostic?
That's fine, Your Honor. I agree. We should be able to get an order to you.
If not, generally any Friday at 8:45, I'll go check with court administration to make sure that I don't think I'm out anytime in the next few weeks, but I never know.
Right.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Just 1 second here. All right. Got the Thompson Flanagan matter, which is 19-2-95508. Mr. Anderson. And who is on the other side of this?
Cliff Wilson, Your
Cliff
Honor.
Wilson, there we go. I had you hidden behind another screen there. My apologies.
No problem.
All right, so this is on, excuse me, for defendants motion for summary judgment. Get the right paper. We got a lot of paperwork there going around. So, all right, got the right stuff in front of me. Counsel, go ahead.
Thank you, Your Honor. And just, I guess, as an update, since we've last talked with you about this case is a matter of a neighbor dispute that started way back in 2016. It was previously set for trial a couple of different times, I think, most recent of which was, I think, in January. It's now set for trial in front of you on August 7th, I believe it is, so a couple of weeks away. We felt it appropriate based on some new facts that have been developed in the progression of this years-long case and a recent decision by the Washington Supreme Court that it was appropriate to kind of address these issues summarily again, in particular, given the fact that this case has now been placed onto a bench trial. So there's going to be a decision made, whether it be in August, after the bench trial, or now on the issue of the facts application to the law. And as you probably may remember from the times we've been before you in the past on this case, the facts are really not disputed, or at least there's no real issues to the material facts that in dispute here. We've got some decorative rocks that my clients, the Flanagans, placed on a portion of their property that is part of this roadway easement that is at issue. You've seen the photographs, hopefully, in our motion of the riprap that is there. This is certainly not roadway in terms of the paved portion of the roadway, but rather this kind of decorative and area that is not designed to be driven on or not to be as roadway. But in any event, you ruled many years ago now in 2020, it is the conclusion of the court that the CCRs do bind both parties and the use of the road easement. And with that ruling in place and the fact that, as you may recall, back in 2016, the Thompsons petitioned the Homeowners Association with a complaint about these rocks. Homeowners Association, at the time, both Mrs. Flanagan and Mr. Thompson were board members. They recused themselves from that process or that decision. The Homeowners Association board collectively got together. They evaluated the complaint and they made a determination in favor of the Flanagans. I'm sorry, yes, in favor of the Flanagans, and then the Thompsons brought this suit. Been a lot of discovery, been a lot of different depositions. We've tried to encapsulate that to the best we can in our submission. But and just to recap, I guess what we've asked of the court is that we believe it's clear that under the CCRs, the Homeowners Association has authority to make this decision. We think that the recent case of Bangerter requires the court to evaluate this discretionary decision, and it owes the decision made by the Homeowners Association Board substantial deference. There's been no evidence from plaintiff's side that there was any, that the process was somehow inappropriate, and that the conclusion and the decision of the board from way back when was invalid or fraudulent. And we think the case is very clear that that requires substantial deference by the court in that case. And again, I haven't heard any evidence that would suggest that that decision was somehow invalid, at least under the analysis that Bangerter kind of provides us with. And then I guess in the alternative, one of the primary issues here, I guess, has always been Mr. Thompson's kind of claim that he has some right to use this portion in some way different than what Sally Flanagan, whose property it is, subject to the easement, subject to the rules of the CC&Rs, differently than what Sally wants. And this ingress and egress thing has kind of been this elephant in the room that Mr. Thompson has testified that it does not stop him from egress or ingress into his property. He specifically testified that there's never been a time when he couldn't get his trailer in and out of his property. And, he did attach a declaration to their response that indicated that, well, it's hard, or it causes problems, or I'd like to do it differently than I can. But, we believe that just on the issues of egress or ingress, he has egress and ingress into his property, which is the opposite side, of course, of the roadway from the Flanagan's property. We've been at this case a long time. We're prepared to proceed to trial on August 7th. We think that it should be decided summarily at this stage because there's really no issues of material fact. And, the law, it needs to be applied. And you're the lawgiver, whether it's now or whether it's at the trial that's coming up in a couple of weeks. So we think it's appropriate to make an attempt at a final summary judgment on this case.
Thank you. Mr. Anderson.
Yes, Your Honor. I'd like to start off by talking about these alleged changes in the facts and in the law. Has Your Honor had a chance to look at my brief with regard to those depositions when I broke it down?
I reviewed all of the briefs and declarations that you both filed. I went back through my prior decisions, and because a great deal of this has to do with kind of specific language, which I refreshed my memory on because I hadn't looked at it for a while. And those two maps that are 2 or 3 maps that are attached. So I did go back through everything and read it all.
So I'm going to touch on those first, on those changes and why this is the same motion and why Your Honor should stick with what Your Honor had already decided. And then I'll get into the 3 cases that tell us exactly how to rule on this and exactly what needs to happen in trial. So there are questions of fact. Just because it's a bench trial doesn't mean there are no questions of fact. At the end of a bench trial, we have a findings of fact and conclusions of law. And we'll talk about the factual question at the end under Thompson v. Smith and Littlefair v. Stoltz. As far as the depositions, if you look at the depositions, what you'll see is there is no one that believed that the HOA was acting in any capacity other than deciding whether it would enforce the covenants. There's no one that believed that this was an adjudication. Both of the board members testified that they were deciding it for the HOA, and if there was a litigation about it later, it wasn't their concern. It was a decision whether they wanted to enforce this or not. Mr. Wilson just ignores that stuff, just keeps moving forward. The question of, was this a proper decision? They didn't even know that my client had an easement. Both of them denied that my client had an easement. They thought my client was just trying to tell someone else what to do with their property. They never acknowledged that. Ms. Boyd talked about all the things that she did. She talked to her girlfriend about it. She talked to the county about it. She did this and she did that. But they all agreed that they were deciding whether they were going to enforce this by the HOA or not. And Mr. Thrust himself said this was the end, this was the final decision for the HOA. Whether the parties continue to fight about it or not is up to them in a decision later. And I provided that. And Mr. Wilson just ignores it. He just pretends it wasn't there. Like he does with Article 4, Section 1. The most disturbing thing about this whole thing is Mr. Wilson can't bring himself to even say Article 4, Section 1, to talk about how it says specifically in the covenants that each individual owner has the right to bring a court action to enforce the covenants. And inaction by any party is not a waiver of that right. It says it there. How do you ignore that? How do you not even address it? In the 3 times he's brought this motion before your honor, he's never even touched it. He's never even talked about it. And it's really important once I get to the Wimberley case to talk about that. The other thing with this Hangarter case, it's no different than Risk versus Angel. In Hangarter, the facts of that case were the homeowners were unhappy with how the HOA was assessing fees on the subdivision. The HOA had made a business decision that we're going to assess fees in this manner between each homeowner, and the Hangarters didn't like it. So they filed suit to try to make the HOA change its mind about how it would run its business. And the court applied the business judgment rule. That's what happened in Risk v. Angel. And again, when we get to Wimberley, we'll talk specifically about that. That changed none of the law here, because my clients aren't suing the HOA and saying, you need to change your mind and take action against Flanagan's. My clients have their own rights here under the covenants. So with regard to these zones, again, I challenge Mr. Wilson. He's got this fantasy that the HOA has created a roadway zone and a drainage zone and another zone. Where is that in the record? I asked him, he's been to the court now 3 times. He's pitching this to the judge. Where is that in the record? Who made these zone decisions? He never says, because it was never done. But even if it was done, your honor already decided that under the MKKI case. My client has the right to the easement independently of the covenants through the plat. And your honor decided in a written decision under the MKKI case that the HOA can't shrink the ingress egress down to 25 feet, 22 feet from 50 without involving the county in that decision, because it was a plat. Your honor made that decision, put it in writing. Mr. Wilson came back 6 months later and attempted a clarification motion, which was the same motion again. Your honor denied that. Now here we are again with the same argument, the same zones, the same graphics in his brief, without citation of anything on the record, to say that this was done. And even if it was done, it can't be done under MKKI. If we look at Wimberley, now this is the one that's most directly on point. In Wimberley versus Caravello, the Wimberleys didn't like the Caravello's garage. They said it violated the covenants. They asked the HOA to take action against the Caravellos. The HOA said, no, we're not doing it. We're going to leave the garage where it is. The Wimberleys filed suit against the Caravellos to have the garage removed. The trial court agreed and ordered the garage to be removed. And on appeal, the Caravellos made every argument you're hearing right now. They argued under the broad powers of the statute that the HOA had the ability to decide the case, and that your honor, must give them deference. And the court said, no, we don't give them deference. You're talking, and they referenced Risk versus Angel, and that's the same case as a Hangarter case. If you're suing the HOA for a decision the HOA has made and wanting the judge to change the HOA's mind, that's the business discretion rule, business judgment rule. But when you're enforcing that action on your own right, it doesn't matter what the HOA decided. In Wimberley, they went to the statute. Caravellos went to the statute and said the statute gives the HOA these broad powers. And the court said, no, look at what the statute says. The covenants control. And in the covenants, there's an Article 4, Section 1, just like ours. Individual right. Every argument that they've made in this case was decided in Wimberley against the people that are basically the Flanagans here. Every single one. Wimberley tells the court exactly what needs to happen. We need to have it. There's no one has said that the HOA has the right to adjudicate or run an arbitration. It specifically provides the opposite in the covenants. So what do we need to do? What happens when you have a 50-foot wide ingress egress easement and a 22-foot wide road? Thompson versus Smith, Little Fair versus Schultz tells the court exactly what needs to happen. My clients have the right to use the easement and also, quote from Little Fair, ancillary uses of the easement. In Little Fair, the question was, again, you had a fence built directly on the roadway, preventing people from going off the roadway and using the shoulder. The court said that needs to be removed. That's inconsistent with the right to use the roadway because over a number of reasons, because you can't go off the roadway if there's an emergency. There's a shoulder there, just like everywhere else in the subdivision, there's a shoulder. And you raise the concern of adverse possession. You have the right to defend your adverse possession. In our case, everywhere in the neighborhood, and this is in the record, my client provided this, a 6-foot shoulder is provided on both sides of the road by everyone in the neighborhood. This thing they call riprap, it was added by his client. Mr. Wilson knows that. And it's not riprap. I've seen riprap, I'm sure your honor has, it's 12-inch to 24-inch rock. Look at the photograph. If you look at the photograph, you'll see it doesn't extend the full length of it. It's just landscaping that was added. The shoulders are that my client's declaration provides answer uses that it interferes with. So there's a question of fact. Do the boulders interfere with my client's ingress egress and the use of the shoulders? Do they have the right to that? A 6-foot wide shoulder like everyone else, and I think we go to the trial for that. But this Wemberley case, your honor, in Wemberley, literally, Wemberley sued, asked the HOA to make him tear the garage down. The HOA said no. In our case, my clients asked the HOA to make the Flanagans move the rock. The HOA said no. Wemberley sued the Caravellos and won. And the Caravellos appealed and said, we're stuck with the HOA decision. And the court said, no, it's the exact same argument Mr. Wilson's making. And again, why don't we talk about Article 4, Section 1? Why don't we talk about it? And have Mr. Wilson point out to you in the covenants where it has the power to arbitrate decisions and bind people. Where was the hearing? Was there argument? Did my clients present evidence? I think the part of of our papers where it goes into the testimony from the board members shows that they were just making a business decision on whether they wanted to enforce the covenants. I think your honor got it right the first time. The first time your honor ruled on this, your honor said we're going to have a trial based on whether the boulders interfere with my client's ingress egress, and that's what we need to have happen. This is the exact same motion that was done back then. It was done a second time. Now it's done a third time. And your honor, the defendant, she's got an insurance attorney. This is all free to her. She can waste your honor's time with repeated motions, cost my clients thousands of dollars.
Your honor, on that point, I'm going to move to strike. Mr. Counsel knows that's improper and it's not even true. And he has no evidence to actually support it. So if he's going to actually pontificate on things that he doesn't even have a basis to understand, he probably needs to actually provide that basis. And number two, even if it were relevant, how I'm being paid or who or how much, it wouldn't be appropriate to bring it up in a motion for summary judgment hearing.
I think for a Rule 11 motion, it is, your honor. And it's ironic to have Mr. Wilson with his graphics tell me that I need to point to the record.
Well, I don't know that it's relevant to my decision today. So
okay.
I
have nothing to add, your honor.
Okay. Counsel, in response?
Yeah, in response, I guess I would just say Article 4, Section 1. I'm not afraid to say it. I've read what it says. I see what it says. Article 4 or Article 7, Section 1, which I think is what counsel may have actually meant to be referring to. But in any event, we've read all of them. We've read all of the articles, all of the sections. We're here today for, again, years after this dispute first came up. And I believe the court did already rule on this issue that it is the court's conclusion that the CCRs do bind both parties and the use of the road easement. If I'm wrong in that, or if I misread that, please let me know so that, obviously in a couple of weeks, we may have a different issue or be able to provide testimony and evidence that the court needs. But the CCNRs are applicable here. The CCNRs are applicable. There was a process that was put into place by the board. The parties both participated in that process. They found for the Flanagans, Mr. Thompson didn't like it. He has the right, it would appear, to file suit, and he's done that. But we think that Bangerter specifically says that absent any evidence that what the homeowners association did was fraudulent or somehow otherwise invalid, this court owes that decision in favor of the Flanagans substantial deference. And that's all we're asking the court to do, is to apply that substantial deference. And the mere fact that there is still no evidence, despite the declaration, despite any testimony that's been taken, despite any of the plaintiff's burden that they've carried throughout the course of this long-lived litigation, that Mr. Thompson's right to egress and ingress to his property on the other side of the road from the Flanagans has been impacted in any material way other than he wishes that the rocks weren't there, the boulders weren't there, decorative rocks. I don't care what we call them. This is not a matter of words. It's a matter of what rights does Mr. Thompson have to tell Flanagan what she can and cannot do on her property, notwithstanding the restrictions, the CCNRs, and the easements that everybody recognizes as being in place, including the Homeowners Association Board, who has already made a definitive decision on this. And that's all we're looking for. We're not trying to get out of the trial. We are the ones that tried to put this case on the trial docket because it languished out there for so long. We want to try this case, and we'll do it in August. But it does seem to me that because you'll be making the ultimate decision in a couple of weeks anyway, the evidence that's before us, as I think has been even argued here today, is really all there is to evaluate. I am all for trial, us doing a site visit to this property. You can actually look at the things and not through pictures and that kind of stuff. Mr. Thompson has been driving his trailer. He's had a couple of different types or different sizes and different trailers as we understand it, but he's been getting it in and out of there, according to his deposition testimony, several times a year without any actual problems doing so. His testimony was that he's never had to hire somebody to do it. He's never had an occasion where he couldn't get his trailer in and out. And, here we are arguing about this case 8 years after it was originally decided by the homeowners board because Mr. Thompson doesn't like losing.
All right. Well, thank you, counsel. I seem to have been doing an awful lot of research on a lot of cases recently, so I spent some time researching this one again. First off, Article 7, Section 1 does give plaintiff the right to pursue this in court. I think anybody has convinced me otherwise. I think it's black and white what it says. I don't see how this new case necessarily applies to these facts. This is a case where you got a 50-foot easement that's put into place for everything. Not a 12-foot road, it's a 50-foot easement for roads and utilities and drainage. And as was indicated earlier, there's never been a designation of what's what. The fact there's a road sitting where it's sitting. The road could be all the way to one side of it, completely on one person's property, or it could be all the way on the other side. And no one would have a right to complain about that because that's the road easement is 50 feet. So it could be literally 2 inches from the property line or the edge of the easement. So the the fact that the road is sitting where it sits is not a particularly relevant fact for determination of this case. I think, I mean, I've read all the cases cited by counsel. There's another case, and this is 173 Wash App 778, which is Northwest Properties, Brokers, and Early Dawn Estates, which seems to me is kind of where this case sits. We've got an easement that the homeowners association they've essentially placed a road, or somebody placed a road where they placed it. I've not seen anybody have anything provided that the homeowners association has said that there's the road, there's a 12-inch, 14-inch, 6-foot, whatever shoulder or anything else. They just don't want you driving on the edge of the blacktop because it breaks, which is a legitimate concern. That's part of their road rules, but it doesn't change the underlying easement that's there. The only language anywhere through any of this that talks about ingress and egress really has to do with whether or not power companies or the county can get in and maintain utilities. It doesn't really talk about ingress and egress for the tenants or the owners any place. That's really the only section that talks about ingress and egress. So really, if I look at this Northwest Properties and Early Dawn Estates, what it talks about, and this is where you talk about interference with an easement. And it has to do with what's the degree of interference that the dominant estate is being put under by the serving estate, whether it's a gate, whether it's a fence, whether it's a bunch of rocks. You know, what is the degree of the imposition on the use of that easement? And I think that's what it boils down to, is whether or not it's reasonable to do what's been done, and which has to be determined based on, I guess, a trial. And when I read through the declarations, I don't know that I can make a decision based on that necessarily, because I've got kind of cherry picked portions of declarations, and so I'm going to deny the motion because I think my earlier decisions based on all the case law, including this new case, I don't think that changes anything with regards to this case. I think there are cases where it would apply and would change my decision, because this is not, let's say, for instance, the homeowners association had said that nobody can drive off of the blacktop as a policy. I mean, they've said that they don't want you driving off, but they've not said you simply can't use the shoulder. Would that be, then I would have to give them reasonable deference to their decision because they had made this kind of equitable rule for everybody. This is a specific decision on a specific case where the plaintiff has an absolute right under the CC&Rs that were put in place at the time this thing was created, which the board can't change because they have to go through the county process to do that. That he can go to court and bring this up on an individual basis. Again, that probably, the new case probably does limit what the Thompsons could do as far as certain types of decisions. I don't think that's this one. So based on all of the reasoning that I gave the last times this was in front of me, in addition to this new research, again, I don't know if you caught that slide. If you wanted, I'm happy to repeat it. It's 173 Wash App 773. It's a 2013 case, so I don't remember if I've read it before, but it really talks about, you know, how much of the easement rights are being impeded. This had to do with a gate being installed, whether somebody, you know, had to have access to the gate or that type of thing. So and they allowed the gate, but it had to have certain parameters to it. So it's really kind of more on point with the issue here. So, all right.
Your Honor, I provided an order that per the rule cites everything that Your Honor would have considered in the written record, or that was pointed out to the court, and simply says denied without any additional verbiage. I don't know if council's had a chance to look at that.
I think we did get it. I unfortunately don't have it here in my notebook. I don't have a problem with an order if it's limited to that.
I'm looking at that proposed order. It says that, that I've considered the documents listed in Exhibit A, and I'll go through that. And it says essentially, defense motion is denied. That's the extent of that order. The Exhibit A includes motion for summary judgment. That's what's listed.
Yeah, and as long as it's just the denial, I'm fine with that. Thank you. Your Honor. Sorry, I didn't have that right in front of me.
I don't know if you can see that. That's the order.
That works. That works. Thank you very much.
I'll sign that order, and then and just for the record, I may be the one hearing this. I don't see it on my necessarily on my assignment calendar, but I won't know that until a week before trial. That's usually done on a Tuesday, the week before, as to who has those. I may do it. And if so, I'll look forward to hearing it. It'll be an interesting case. And if not, someone else will make the same decision that I would have made had I heard it. I don't know what that's going to be till I hear the evidence.
All right.
Thank you, Your Honor.
Thank you for your time, Your Honor. Thanks.
You're welcome. Have a good afternoon.
Bye.
All right, and then I've got Tejada and Wynn. Let me get back to that now. I'm just going to go through that as we do it. I think that will be probably the most efficient way to address that. Just a minute here. All right. So I'm going to work with the motions in limine first. And it looks like, so 1 through 3 are agreed. Is that correct?
Yes.
Yes, Your Honor.
Okay, so we'll grant those 3. Let me go through, and 5, 6, and 7 are agreed.
Yes.
Okay. 10 is agreed. 12 and 13. 15. And then 18 through 23. Okay, so let's look at number 4. All right, and see here. Counsel?
Yes, Your Honor. This is one of the ones that I would like to argue. There are several where I think the parties are basically in agreement. As a side note, counsel for the parties did confer on the jury questions and questionnaire, and we have reached an agreement on those.
Okay.
So we don't need to argue on that today. We did not have a chance to confer on the motion in limine ones, but as I just mentioned, I don't think there's going to be a substantial amount of argument except on numbers 4 and 17. So I'm asking the court to exclude in the presence of the jury any suggestion that an award of damages will not make the pain go away or will not make my client whole or something to that effect. That's pretty classic jury nullification, basically telling them that even though the law says that we award money damages for pain and suffering and injuries, basically telling them that that's not an appropriate way to reward or compensate the plaintiff. That's my argument.
Counsel?
Yeah, and I don't necessarily think that that's my argument, that I don't have an issue with that. I don't, I agree with that part of it. I think where plaintiff's motion in limine goes a little bit too far is to say that the money's not going to take away his alleged symptoms. And I think that's different than saying that then that's not jury nullification. That's just a simple statement that, he's alleging all this pain. Just because you give him money doesn't mean the pain's going to go away. I don't, I think the jury's quite capable of listening to argument, looking at the jury instructions, and determining what a proper, fair, reasonable award should be.
Right, I guess what if the purpose of an award in an injury case is to compensate for the injury, what would be the basis of making an argument that it will not fix the pain?
Well, because it won't. I mean,
What's the relevance of that argument or appropriateness of that to a jury?
Well, what the plaintiff is asking for, I interpret it, is that she's trying to avoid any argument to say that, giving him money isn't going to fix this, or, and taking away the rights of the jury. I'm not trying to do that. I'm not gonna die on this hill, Your Honor. This isn't an argument I really foresee myself making. I just thought that the motion in limine went, too far when it says that award of damages will not make the pain go away. That specific statement.
Well, I mean, I guess the concern really is anything that would urge some nullification of the jury. Is what I'm gathering from the nature of that. I guess I wouldn't see how. I mean, if somebody has their leg cut off, we're not going to sew a new leg onto them. So it wouldn't be appropriate to say, well, the money's not going to let you, replace the leg. So, I mean, that doesn't impact how much the leg may or may not be worth to somebody. So it seems to me that the kind of that type of argument doesn't really seem appropriate, whether it's jury nullification or otherwise. And the whole idea, and I don't know, is this a case where we've got admitted liability or not? I haven't gone.
Yes, I believe so. Yes.
Okay, so we got liability, and the issue really is how much the compensation is on the table, and I think an argument that, I mean, it's one thing to say that they lost their car, this money will replace the car. It's it's $10,000 to buy a new car. That's a little different than pain or loss of a limb or things that can't be replaced, essentially. If that makes sense.
It does.
I mean, I think it's totally appropriate to say, yeah, his car was worth $10,000, we own $10,000. That's an appropriate argument because it's true. Or maybe it's 12,000 inflation, but I think to argue that somebody shouldn't get a certain amount of money because it's not going to replace the leg or it's not going to stop the back of her. Again, I don't know all the details.
Yeah. Well, I think the danger that I foresee in this particular argument is if the plaintiff's attorney or the plaintiff argues that, if I get this money, I can go do these things and I can get better again, then I'm not allowed to say, no, that's not what they've argued. That's not what the doctors are saying. This money isn't to make this pain go away. This is money for the non-economic damages that they're claiming.
Well, and I think to your argument there, and I think it would be appropriate, but I'm inclined to grant this with the caveat that if plaintiff opens the door by saying that, that opens the door for you to argue that.
Okay, that's fair. That makes sense to me, Your Honor. And I like I said, I don't anticipate making that argument anyway, but I appreciate that.
And I think that goes for any kind of a pretrial ruling. I mean, if somebody violates the ruling on one side, that sort of opens the door and we have a non-jury discussion about what's going to happen next. But so subject to that caveat, I will grant number 4. So number 8, okay, 8.
So I'm arguing defendant shouldn't be able to make, or sorry. Yeah, defendant shouldn't be able to make arguments about basically that taxpayers are going to have to pay this judgment or it's going to somehow come back on the public at large. Defendant says they have no objection, but plaintiff shouldn't be able to argue sort of the reverse, that the jury should punish the defendant to deter other bad actors in the community. I'm fine with that.
Okay. So I'll grant 8 subject to the and I'll put that right on here. Subject to defense limitation. I think that's appropriate both ways. That work for you, counsel?
Yes, Your Honor.
Okay. Number 9.
Number 9 is my mistake. That was left over from a UIM case. There will be no reference in this jury trial to the insurance industry or the cost of insurance.
Okay.
By either side.
Okay. I'll grant number 9. Pretty normal. Number 11. So based on that response, where does that put you?
I'm agreed.
Okay. So grant 11 with the parameters cited by defense.
Yes, please.
Okay.
Same with 14. Regarding hypothetical questions.
Okay. And counsel, you're good with that? Same?
Yes.
Okay.
Yes, Your Honor.
Grant subject to defense limits. Then we're at 16. Excuse me, I apologize. Expert reports. Any objection to that with those limits?
Just a point of clarification. It says defendant doesn't object, but wishes to clarify that medical records of treating providers with proper foundation is admissible. I would say, I mean, I'm not going to say carte blanche, they're admissible. They may be admissible. So I think we're in agreement on that one. I'm not trying to say medical records are expert reports. I mean, expert reports prepared for the purpose of litigation. That's what 16 relates to. So I think we're in agreement.
I think we're in agreement as
Okay.
well. I try to put by adding with proper foundation, obviously that medical records we need to still lay the foundation, make sure they're relevant, all that stuff. But I just wanted to clarify that it's different from an expert report. That's all.
Understood.
That makes sense. So I will grant that again, subject to the defense limits. 17. Let me hold on for 1 second. If I can, I just have maybe an emergency. Let me give you just 1 second. I'll be right back.
Okay.
Hello?
The judge will be back in a moment.
Oh, okay, sorry, it went blank and I had it quiet. Thank you.
All right, council, I apologize for that. I may have to step back off. We're having some heat related semi-emergencies here. So it looks like I think we're down to the last question, which is number 17.
Your Honor, can you wait just a moment? I went off the record. I'm just getting us back on.
Oh, I'm sorry. All right, back on the record. We'll be back in a moment. We're having our heating cooling system in the Hall of Justice has essentially failed. So due to the heat. All right, stay on the record, but I'll be right back. Hold on one second. All right, sorry about that, counsel. I'm gonna go ahead. I think we're in 17.
Yes, Your Honor.
Okay,
Okay, I just technically, for me to close, it would have to be that court is closed. So. That would be amazing if you can do that, but I don't.
all right.
That a bunch of stuff over and,
Ms. Long?
you know.
Yeah, number 17, this is related to Dr. Hung's testimony. He's the orthopedist for the defense in this case. The first has to do with speculation. Dr. Hung, like many doctors in cases like these, is seeking to testify that any treatment that plaintiff had beyond a 4-month window is not relevant or is not reasonably related to the case and shouldn't be part of his damages award, because in his experience, soft tissue injuries typically resolve in 2 to 3 months. And my argument is that although he testifies that that's based on quote unquote his experience, that's incredibly broad, incredibly speculative. And my concern is that a jury member is going to think that because he's a doctor and because he's testifying based on his experience, that they should adopt that speculation or that assumption that my client was better in 2 to 3 months and that any treatment beyond that window was not related to the accident. And then with respect to, I'm making an objection to the inclusion in the record of a leading question. It's a question that suggests the answer. I mean, I'm sure your honors read it. I feel it does suggest an answer. He's leading him to say, isn't it basically saying, isn't it relatively impossible for you to predict how to replicate every complaint? And the doctor says, yes. That's my argument.
Mr. Wallace.
Yeah, for the first issue, as far as the speculation, Your Honor, I think an expert orthopedic doctor has the knowledge and experience to testify to what he sees on a regular basis with patients as far as the recovery time of a soft tissue injury. In this case, he says that he believes that 2 to 3 months is typical, but he thinks that the plaintiff in this particular case treated slightly long, but 3 to 4 months is still within an appropriate window of treatment. So he took his knowledge and experience in this field and applied it to the facts and evidence. Now, what plaintiff's attorney is trying to do is trying to, in hindsight, go back and take out testimony that she doesn't like, because she didn't cross-examine him on it and she didn't object to it prior. Now, the worry that the jury is going to believe him isn't proper for a motion in limine. I hope that the jury does believe him. That's my case. That's what I'm putting on. And his opinion is important to that case. Now, the plaintiff's attorney can surely bring in her witnesses to contradict that, just like she could have cross-examined him and asked him, how does he come up with that? But she didn't do it. So to merely come back now and say, well, we shouldn't do it because I don't like it, isn't grounds for a motion in limine. With respect to the leading question, the plaintiff asked on cross about asking that the doctor, did he specifically have the plaintiff lift a 20-pound weight that would be consistent with the plaintiff lifting a child that he says he has, that it bothers him to lift. My question didn't lead him. It was just merely redirecting him to the statement and the question that was asked on cross-examination about replicating a situation. So I don't, while it has some leading characteristics to it, it was in redirect to address a specific question asked on cross. So those are my feelings on those two situations.
Well, the first, I mean, the general, anytime someone gives an opinion about anything, it's speculation. I mean, that's what opinions are, generally speaking. They're opinions based on an assumption of a certain set of facts, and then an expert basing it on their knowledge and experience as to what that means. And that's what experts do to some degree. Let's get back here to the. I think with regards to the opinion that, and I guess this is the full quote that is listed on page 3 of the response. It would seem as long as that entire quote is there, I would allow that. I mean, assuming the video deposition is coming in at all, I wouldn't limit that out of it, if that makes sense. As far as the leading question, I'm just looking at that. I mean, I think anytime you end a question with the words, is that fair? First off, I don't know what that means. Does that mean that it was equitable as opposed to, I mean, that's a question that doesn't make sense to me. But it is a leading question, I think, in common parlance. And assuming that's the case, then the answer is non-responsive because it would either be yes or no. It was objected to, so and it could have obviously been rephrased in a way that wasn't leading. I don't know if that was done, but if that's the yeah, I mean, I guess I would have made the objections being relevant, frankly, but I'm not sure what is this? I guess what does this do? It doesn't say anything to me, frankly. This long?
I understand your points about it being non-responsive and then the answer itself being being relevant. I mean, but I feel like I'm bound to the objection that I made on the record, which is leading, so.
No, I understand that, and it's leading, although I don't know that it asks, I mean, the wording of is that fair is certainly not any kind of grammatical question that means anything in a case, frankly, so. But I guess if you assume that means is that true, then that would be leading. And then the answer is non-responsive to that question. But so I think on the basis that I don't see the relevance. It is a leading question, at least under one interpretation. The answer is non-responsive. I will keep that out.
Okay, and to clarify, the portion that Your Honor is excluding is, and there's the transcript attached to the motion, is page 28, line 10 until page 29, end of line 2. And then from there it can resume.
Understood.
Okay.
And to be clear, Your Honor, the first part of motion limine 17 regarding speculation is denied.
Right, I'm going to allow the first half and deny the second. Well, I'm denying the first half, I'm sorry. It doesn't work on this order very well. I'm going to put allow. I'm going to call it speculation, although I don't know that's because it's a form of the request.
Mm-hmm.
And deny on a grant on the leading. Okay.
Okay.
So I will enter that order. Let's see. You've indicated that you have agreed on the questionnaire.
Yes.
So do you need anything on that one at all?
I just need to know how do I, you know what, I know how to do it. I've got it. They're signed by counsel. I will route them to the court to you for your signature.
Okay, those will probably just need court administration, and then they'll get them to wherever they need to go to get printed and ready to go for the jury.
Okay.
I'm going to put on the order. I'm just going to put that agreed questions to be submitted.
On which order?
This is on the order on proposed jury questionnaire.
Well, we have an agreed order that's different than the one you have.
Okay. I'll talk this one and I'll wait till I see that order.
Okay.
The last one was on the questions for the jury. Let me take a look at that again. Generally, these I just have you submit what you're requesting to the trial judge, and they will either include them or have you ask them yourself. But let me just take a look here.
Okay. And these are also agreed with one change.
If you've got an agreed statement of questions you want included, if you want to just submit that, then whoever does the trial will just include that.
Okay. Would you like to, or do you need to sign an order in that regard, or you don't want to?
I don't know that I need to, because if you're both coming forward with agreed questions,
okay,
then if there's a disagreement at the end, that could be handled as a motion and eliminated at the beginning of trial if there's some disagreement on a particular question.
Okay.
All right.
Yes, thank you, Your Honor.
All right, I signed this motion and eliminate with it's kind of scribbly, but it's you took better notes than I did, I'm sure. So that'll go into my clerk, and just for your reference, we are closing the courthouse due to heat problems here. So you're our last case for today.
Yeah.
Thank you, Your Honor.
All right, so it looks like we do have somebody in the Zoom room.
Yes, I've been here, and my name is Mandy Gronitz.
We handled that case a long time ago, I know.
I have so many cases. I was told yesterday to be here and I've been waiting in the courthouse. It's so hot in here. But I've been here since like 1:30. But I don't know. Did you see my case today? Because it took a while for me to get into the Zoom meeting box. I tried this morning at home. I'm not a Zoom person. I apologize.
We did, I know, I'm just going back to see what we did on that. I know we heard that case. It was probably about 2:15.
Yeah, I was in the courthouse just waiting. I was sitting outside the Zoom. They just couldn't log me in.
Rhiannon, do you,
Yes, you had said that you would be approving it, and Ms. Winkles was to prepare an order and circulate it tomorrow.
I'm just trying to find, okay, there it is right there.
I think this of the motion to show cause. I honestly, this petitioner, my first husband, have handed me a dozen cases in the last month, so they're kind of overlapping and getting mixed together.
Well, this one has to do with return. It looks like it's of a.
Not irrelevant, but we haven't even done our dissolution yet. So, is there anywhere in the system that he's filed a order to end our committed relationship? Because that's the paperwork I'm working on, which I think is the beginning of where we need to start. We have to identify who owns what.
That's not this case. This is a different case.
Well, if, is this the case of the Replevin and motion to show cause? Is that what we're doing? Is that what you're?
Right, this was on to return the vehicle.
Right, but it's my vehicle. Jeff's denying we're married or have a committed relationship, even though I'm the executor of his estate. He's kind of gone some medical stuff and
well, let me stop you. I can't tell you about the case, but here's what you go to the courthouse at 1:30.
Approximately, yeah. I'm not sure what time I pulled my actual ticket, but I was number 231, or it was on number 231. I was 240, and it took like a half hour to get seen, and then it took like another however long to get in the box. So I didn't look at the time on what time I actually got into the Zoom meeting, but they said they'd send because I asked the clerk and he said when
I see that here. It looks like that happened about 2:28.
And I checked in before like 10 minutes to 10 to ask if I could check in, and they said I had to wait till my ticket was pulled to even check in.
Okay, so what I'm going to do on this one, Rhiannon, I'm going to hold off on that order. We'll need to notify Ms. Winkles that it'll need to be set back on. Because she's obviously here. It sounds like she's waiting out in the lobby to get in. And
so was there just I'm sorry, I don't know what I missed, but we're gonna hold off. I need another court date or what.
Well, here, ma'am, I just listen. Okay, what I did is when you weren't here, I ordered that the writ to turn the car over was granted.
Oh, okay.
So, I mean, I'm going to set this back on probably for next week. I'm going to have them re-noted on. And
yeah, it really should be reset because it's going off of a protection order and we haven't even met for that.
Well, that's a whole separate issue, but it's all I'm talking about is one thing. And this is the case number. It's 23-2-53908.
I think I should have that.
Okay, that's what this is about.
My attorney had my paperwork until yesterday, and okay, so I have.
So here's what I'm going to strike that. I'm going to suggest you get a hold of Miss Winkle's office. I'm going to send her an email.
Okay.
I'm going to send her an email indicating I'm holding off on the order because you were stuck in the lobby, unable to appear, and have her re-noted on. And she'll need to give you notice of that hearing date, which will either be next Wednesday or the Wednesday after, probably. Okay?
You said I needed to contact her, or you were going to contact her?
I would suggest you may want to contact her because that may be a simpler way to get paperwork back and forth.
Okay, well, here, maybe I can just find her in the lobby. Okay, and so then you'll send the email and then I'll wait for a notice.
But I'm gonna just have her renote it and give you notice of that court date. I don't know what date she's available, so.
Okay, and the reason I knew about today was because I called in yesterday because I got served extra papers last week from my first husband. So
I don't know anything about that. I'm just talking about this case. It's the only case.
Right. So I'll follow up. Thank you so much for taking your time today, Your Honor, and I do apologize that I was.
Sometimes things happen with our Zoom, but that was not obviously your fault.
Yeah, I tried at home. I'm gonna try at home, but this little Zoom box is not my gig.
Okay, that's fine. All right, well, I'm gonna strike the order that I signed or was going to sign. And we'll get it renoted and give you an opportunity to hear what you have to say.
Okay, is there a way to pick up that paperwork at the clerk's or?
There won't be any paperwork at this point because I haven't seen the order yet.
Okay, I'm just on paperwork collection mode right now. I haven't even started dishing
All
it.
I'm gonna do today is not sign an order and I'll have Ms. Winkles recited on for hearing.
Thank you. Appreciate your time.
Okay,